Good morning, dear human rights students. In the year 2021, there is a question number 18. The brief facts are like this. A is a party to the Child Rights Convention. That means let us take India. India is a party to the Child Rights Convention by the UNO, right? But they wanted to pass a legislation that the children between the age of 8 to 18 years, they can engage or they may opt to work in any factory if they are not interested in studies, right? But a human rights organization criticizes the legislation as violation of the Child Rights Convention. Discuss whether it is correct or not. So the argument or the criticism by the so-called NGO is 100%. NGO means human rights organization. 100% correct. Because now let us do. The issue is whether the government can pass a legislation that the students or the youngsters can work in any factory if they are not interested in studies. Now you have to go to the discussion. Before discussion, you have to discuss or you have to apprise the paper with the United Nations Convention on the Rights of Child. I have given 2 or 3 types of rights of the children in my notes. Right? Of course, that is not sufficient. I want to focus on this particular question. So, there is United Nations Convention on the Rights of the Child 1989. There are so many articles in the convention. So, the convention says children are human beings with own rights. That means they can express their rights. But they are separate up to 18 years. They are separate, particularly up to 6-14 years, because they have to develop, they have to grow, they have to learn, they have to play, they have to flourish with dignity. So therefore, free and compulsory education, even our Indian Constitution says, Article 21A, free and compulsory education up to 14 years. So between 14 to 18 years, we call them as adolescents. Of course, then the Protection of Children from the Forced Labor Act 1976, presently you can call it as Child Labor Prohibition Act 2016. It has come into existence. Of course, there the children, they can take part in the family's avocation during their vacations. When the school is not there, they can go to the tea shop where the father is working and he can assist him also. That's a different aspect. Here, the point is, the government wants to make a law stating that they can go to factory. Even the Factories Act, even the Mines Act, they say that the children should not be employed in the factories. Children should not be employed. Children should not be employed in the factories where the hazardous process is going on. So definitely no. Right? Now you have to mention a couple of articles. Please remember, Article 12 says, child capable of, please remember, capable of viewing or expressing his own views, definitely he can be allowed to express his views freely. Article 28 of the United Nations Convention on the Rights of the Child 1989. Article 28 says right to education. So make primary education compulsory. Provide higher education accessible to the children. So please remember, in India, which is a signatory to the United Nations Convention on the Rights of Child. So they have passed an act in this connection, Right to Education Act 2009. And you may be knowing Article 21A, just now I told you, free and compulsory education up to 6-14 years. And Article 45. Article 45, of course, it is a directive principle of state policy, which states that the state took care of the early childhood care and education of the children. Right? So therefore, the so-called labor legislation or legislation by the state A is not at all acceptable. Definitely, it can be criticized. If you go to the court of law, the government will fail in passing the legislation. Now, you have to mention a couple of case laws, isn't it? So, Now you write down the case laws. That is number 1. Mohini Jain versus State of Karnataka, 1958. Right to education. The constitution was not amended. So at that time itself, she has Mohini Jain versus State of Karnataka, 1958. Mohini Jain, a medical student, she challenged the validity of a private college or the act of a private college in collecting abnormal fee from the students. There, the point has come whether right to education is a fundamental right to the student or not. So, as per Article 21, Honorable Supreme Court of India said, yes, right to education is also a fundamental right. Later, Article 21A has come into existence. Mohini Jain case, please forget. Don't forget. Second case, J.P. Unikrishnan versus State of AP, 1993. Here, there are limitations. No doubt, the state has to give free and compulsory education. But it depends on the limitations of the resources, financial capabilities of the state. So, right to free education till 14 years is limited to the state's economic capacity and also the development. No doubt, there are funds and government will definitely act for the right to education. Already they made an act. So therefore, please remember, to conclude, state cannot make any legislation that children can work in factories if they are not interested in studies, particularly between 6-14 years. So if you write this much, it will be sufficient, I think. Thank you.